Bill Henshaw here again, Constitutional Crisis Channel. This is probably the only kind of a recent story that we're going to have. I do a lot of those, but this is a big one. And I've got a traffic case in Merced that may ultimately become known as the Miracle in Merced. Because after 4 decades of doing this crap and having spent 7 months vacation in the South Carolina jail as a political prisoner, I didn't think I could be shocked by anything this damn system did. I stand corrected. In this traffic case, I'm helping out my friend. We prepared some documents. One of them was a demand for a bill of particulars, dead bang rights secured by the Constitution, and more than one provision. We'll get to that later. And a notice of denial of assistance of counsel, which immediately defeats the jurisdiction of the court. Well, we got a letter back from the court the other day that states that we sent the self-addressed stamp envelope where I thought we were going to have conformed copies of the documents. That's not what we got. What was returned was this. I've never seen anything like this. Now, I know from experience this is a form that is going to be probably promulgated by the California Judicial Council. I got that part, but there isn't anything on it that tells you that. And we get it back, and on the bottom, the only thing they checked there, and this was done by the Deputy Clerk of Court. No judge, no hearing, no opposition, no nothing. And the Deputy Clerk of Court, so wait, let me give it to my cameraman to hold up the part where you can read it. All they checked on the bottom was the section where it says that your request has been denied. Really? It doesn't say what the request was, doesn't identify the documents, doesn't do anything. They didn't return the documents either, by the way. It just do anything. And there's been no order of a judge, which would be required, at least for the demand for bill of particulars, and that only prior to a hearing on the record where the accused can appear and defend in person. That's the foundation cardinal principle of our system of government here. Whether they like it or not, I don't care. This is what they've done. Now, they've done it with the form that I can't see any way can be interpreted to reach this result. And I fired back other documents after we got this one. Now we have a motion to dismiss in there. That's something I'll discuss on a video at another time, because I've changed my position there, which I don't do very often. But I now think we can go in, especially in California, and maybe in your jurisdiction too, and actually do motions. And like I say, more about that later. But we have the motion. We got a 22-page motion, I believe, 24-page brief on a 19-page brief on 14th Amendment, the unconstitutionality. And if we get the hearing, which is tentatively scheduled October 24th, I'll keep you up to date on that part. If we get it, we win, because the DA isn't going to know how to answer these documents, yet he has the sworn constitutionally mandated duty to do so. They have to sustain jurisdiction. We don't. So if there's a hearing on the record, now this is going to get on the record, and the judge is going to sign our proposed order for dismissal and throw the whole case out. If it goes the other way and we get back another BS form, like stupid thing, with a motion to dismiss, now we go right to the California Supreme Court, and when you know, the justices are also the nominal heads of the California Judicial Council, who supposedly promulgated this form. And I'm going to get a letter off to the Chief Justice, I've written it already there, and say, wait a minute, you can't possibly have promulgated this form with the expectation it would be used to achieve this result, unless you're going to tell us that no matter what documents you submit as a pesky pro per litigant, no matter what documents you submit, no matter what issues you raise, your documents are specious, frivolous, and without merit. The legal term for it is res ipsa loquitur, on its own, without any opposition from the DA, without any hearing, without any ruling from the judge, without any opportunity for you to be heard on the record. Is this the point we have reached with this government today? I mean, these are, wow, the magnitude of these issues is even hard for me to grasp at times, and it's a simple little traffic case. But I know from my 4 decades of research that the court takes cases like this because, well, A, they're actually required to. That's a video for another day. But B, they have a loose kind of a rule that it says that they'll take a case like this on occasion which is capable of repetition yet evading review. Now, we'd have a hell of a lot more of those if these damn law school graduate attorneys would raise issues like this that, in my estimation, most of them don't have a clue to start with. So if they don't do it, you don't get the repetition we would like to have. But I'm now sitting here 7-0 in the traffic court in the last 18 months or so, not counting my 7-month vacation in that South Carolina jail. And you wonder how many times it's going to take here. Because we simply have to be able to go in and defend ourselves. If you can't do that, why bother to have the trial? Why not just have the judge sign the verdict that you're guilty, a directed verdict of guilt, impose whatever amount of fine they want to impose, and send you a bill? Why bother with the trial? It's irrelevant in the system in which they're attempting to advocate here. I don't buy that, and you shouldn't either. And by the way, I will note here a distinction with my South Carolina case that I've talked about many times before, but this particular issue hasn't come up. And that was for me that the clerk of court did her job there and filed every document that we sent. Myself and my friend who's doing the videos there, every document got filed there, and the DA there didn't answer any of them. That's what's going to make me a good chunk of change there when I settle this case against these bastards for a trespass via arms. That's a video for another day. But the clerk did her job. That's what they're supposed to do here and should be doing here. And they'll be hearing a lot more at the California Supreme Court about this. And I'll be sending letters to Moonbeam there in Sacramento and the California State Attorney General. I can't think of his name, I think it's Padilla now. It used to be Sacramento Shamala Harris. They're all going to be hearing about this and say, you people better change your ways here. Because if you don't, this is so bad that a room of 4th graders is going to understand it, let alone a jury of my peers sitting there when they're trying me for a criminal case. Absolute no-brainer. They're going to get this right away. They might not even have to go back into the jury room to throw this case out. That's how bad this is. I've never seen anything like it in 4 decades. I thought nothing more could shock me after all I've been through, but I stand corrected here, and it's to the benefit of all of us, because a little decision like this and a little old case like this looks like it means nothing. It has the potential to be a binding precedent across the board against these bastards. It's just the way the system works. They did this in a case called Thompson v. Louisville, 362 U.S. 199, I believe is the site on it. And they took the case. I'll get it for you. Just read it below. You'll see the sites on the cases. And they took the case. It was a $50 fine that this guy got convicted of for loitering around a restaurant while he was waiting for a bus. And he went to the Supreme Court. And actually attorneys did this. I give them credit for this, even though it was a 14th Amendment case, and I wouldn't have done it that way. But they said, wait a minute, there was not an iota of evidence to convict this guy of anything. And the court reversed the conviction and said, yeah, you're right, and we're taking this case because, yes, it was a small amount of the fine, but the issues raised in the petition were substantial, just like they're going to be in the Miracle and Merced case. And they had a later case on this in 1969, I believe, or 70, that was known as the Screw the Draft case, called Cohen v. California. I'll get you that citation on that one. Look under, you'll see the case there. And this Cohen fella, at the height of the Vietnam War, went around the courthouse wearing a jacket that said F the draft on the back, and he got convicted for criminal activity and for violent acts against the government, more or less. And they went to the Supreme Court and said, wait a minute, this is free speech. He had a First Amendment right to do this. And the justices, in reversing the conviction, carefully noted that when he went into the courtroom, Cohen took his jacket off and sat down, so therefore he didn't offend anybody. He was walking around in open space out there with the jacket on, and anybody that saw that was free to walk to another part of the courthouse and not be, bothered to have to read it. So this was a big deal case, and the interesting point for me, and I'm not a big fan, as you already know, of good old Warren E. Berger, who was absolutely horrified that the court even took this case, let alone the fact that he ended up on the losing side of it. But these are the kind of bastards we have to get off there to wear these black robes and think that they rule the world. That's not how it works. And if we work and present the issues that I do and go out there and a lot of us start doing this, now they're going to get the picture that they're not going to get off so easy. They're going to have to do the job that their constitutional oath mandates them to do. This is how we beat the bastards. I still think it can be done. Maybe that's a bit naive, especially given the 4 decades of BS I've been through. But I still think, until further notice, that the Constitution is there, our remedies are there. We just have to raise the right issues, the right forum, and the right status. And I have 2 of the 3 right now. I'm working day and night to get us into the right forum, which in my mind is a federal circuit court in the concurrent jurisdiction exercised by a state court. If we do that, that's a judicial court, and the ball game is over. Simple, because there's no judicial process anywhere in sight in any of these codes that you want to name. Whether it's the vehicle code, the Internal Revenue Code, you name it. Now all these alphabet agencies are going to get their comeuppance, and limited to the artificial corporate entities that they're supposed to be limited to, not you and I. We have never agreed to this. There's been no voluntary waiver of rights. There's been no consent of the governed. I mean, these are major big deal issues. And this Merced case may highlight the whole thing. It's so bad that, like I say, even the room of 4th graders are going to get this one. When I have updates on this, I'll let you know. We've subsequently sent papers into the court to file a motion, as I mentioned. And if that happens, that's going to end the case one way or the other. But there may be some other really good things that happen here too. So I will keep you updated on this, maybe the next time that we visit with videos. And I'll let you know what we have. Thank you.